Number A, on or about July 16th, 2024, it was reported to the Bossier Parish Sheriff's Office that you tried to entice an 11-year-old girl to go behind your house with you. How do you plead?
Not guilty.
B, on or about August 12th, 2024, it was reported to the Bossier Parish Sheriff's Office that you walked up to 6 children waiting at a school bus stop and tried to entice them. How do you plead?
Not guilty.
Number C, on or about August 20th, 2024, it was reported that you were at the bus stop again while the children were present. How do you plead?
Not guilty.
Now, we are about to watch the parole revocation hearing for a serial predator, a man who has been found guilty already of full-on essay of a child. You won't believe the information that I'm going to share with you, the unpacking. He went to trial for that initial charge back in 2015. He was found guilty, and after being found guilty, a judge sentenced him to just, listen to this, 5 years. Yes, 5 years for full-on essay of a child. And the judge sentenced him after being found guilty in a bench trial to just 5 years. But wait, I'm not done. Don't worry. When he finished serving his sentence of 5 years in 2020, he was then arrested and booked and found guilty of full-on sexual assault. This is in 2022. I'm not making it up. Now, how is it possible that he had then gotten out in 2024, or dare I say earlier, now to get revoked again for approaching children? I have no idea, but I'm sure someone in Louisiana does. A judge, a DA, they probably know. This is madness. Now let's watch this quick revocation hearing where justice is frankly done, and I'll share the appeal and go through those details just in case you couldn't believe it, because I know I wouldn't. I wouldn't unless I seen it. And let's jump in.
Hey, good afternoon. The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. And today on the panel to my left is Mr. Chillis, to my right is Ms. Stapleton. My name is Ms. Ledoux. We have a revocation before us. Sir, would you please state your name and your DOC number for the record?
Paul J. Norman II, 702287.
Okay. Mr. Norman, do you have a parole revocation questionnaire in front of you?
Yes, ma'am.
Do you recognize your signature on that?
Yes, ma'am.
Okay, the answers to that question indicate that you are not eligible for appointed counsel. Sir, I'm going to be reading some allegations against you, and then I'm going to ask you to enter a plea of guilty, not guilty, or guilty with a statement. As a sex offender, you have special conditions that you have to keep. You have a separate sex offender compact that you have to keep, and you have been accused of violating number 13, A, B, and C. And I'm going to read this to you. You are not allowed to have contact, including living in the residence with children under the age of 18 unless consented by the court or the parole board, and that includes your own children. Number A, on or about July 16th, 2024, it was reported to the Bossier Parish Sheriff's Office that you tried to entice an 11-year-old girl to go behind your house with you. How do you plead?
Not guilty.
B, on or about August 12th, 2024, it was reported to the Bossier Parish Sheriff's Office that you walked up to 6 children waiting at a school bus stop and tried to entice them. How do you plead?
Not guilty.
Number C, on or about August 20th, 2024, it was reported that you were at the bus stop again while the children were present. How do you plead?
Not guilty.
Okay. Mr. Norman, the officer who prepared the report for us also included almost 2 hours of video cam footage of interviews with parents and children all along your street. Let me hear your side of the story.
Well, all I know is that when I was paroled for the current charge that I'm on, as soon as I was out on parole, that's when I started having problems with my neighbors. And ever since then, every time I would walk outside or on my porch or down to my mailbox, they would come out, look at me, get on the phone, and the next thing I would know is that the sheriff's office would show up at my house, snap pictures of me, and then take off. And this has happened multiple times, until I got sick of it. So I called the sergeant officer with the Bossier Sheriff's Office and told him what in the world's going on. Why are these sheriff's deputies always coming by my house, snapping pictures of me? And the neighbors, one of them that lived across the street from my mother's house, she would go around to each neighbor's houses, like, I guess, trying to incite a riot or whatever she was doing. And all I know is that one day, it was like maybe a month later, after all these stops by the sheriff's department at my house, I was approached by Sergeant Offer and said that I was brought up in an investigation on allegations and he would like to question me. And when he advised me of my rights, I told him that I would need to consult with an attorney. And that's when he stopped the investigation and left. But
Okay.
every single time I would walk outside, the cops would get called on me for no reason.
Actually, sir, the first call to them was on July the 10th, and you were detained on August the 7th. So you make it sound like this long, drawn out. I'm just reading facts of the report, okay?
Yes, sir. Yes, ma'am.
And we also have the witnesses, the child who was interviewed. You were giving gifts to a child. We have it in the folder. And so that looked bad.
I understand. I've never approached any children. I've never talked to any children at all, because they've even tried to involve my mother, who's a senior citizen, on this, saying that she was doing it also. I mean, I just got tired. I got sick of it.
Yeah, the officer was very complimentary of your mother, and so were all of the neighbors. And they were not trying to involve your mother in anything, okay? So leave your mom out.
I understand.
Okay. Sir, do you have any questions, Mr. Tiller?
No.
Ms. Stapleton?
No, I think the video and interviews speak for themselves.
You know, I spent a very long time watching all of those videos. 1, 2, 3, 4, 5, with detailed information about what you were wearing and where you were standing. These are not people who are harassing you. Okay?
They are. I know it's hard to believe, but God's honest truth, these people have done nothing but harass me ever since I got out on parole.
Okay.
But with all due respect to y'all, I'll do respect. I'm just here to state the truth. And God, God in heaven knows the truth. I am not lying to y'all or anyone else.
Based on the preponderance of evidence that we have before us, my vote is to revoke parole to all of the allegations against you. Mr. Tillins?
I concur. My vote's to revoke.
Ms. Stapleton?
And my vote is to revoke.
So today, based on a unanimous decision, your parole has been revoked. The time is now 12:50, and now we're wrapping up our business at Caddo Correctional Center. Thank you.
Yes, ma'am.
All right, so they made quick work of him and they revoked him, but I don't even know how much time he's back in again. I'm stuck on the idea that he received a 5-year sentence after having a bench trial. And thankfully, there's an appeal because no, he wasn't happy with just being sentenced to 5 years. He had to appeal. So we have the facts. And the facts that I'm about to read to you, it just shows how broken Louisiana is, all the way from the legislation, those who write the laws, to the judge that hands down the sentence. Those put in position to protect our most vulnerable, there's something screwy with them, at least some of them. And this is proof. There's no denying it. 99% of us would agree that this is pure madness. And I'll read it to you. And this is not even talking about the fact that after he was released, he was then, I mean, it says here in the notes that he was found guilty of SA, and it shows up in his registry. So I don't know how he's out and about again to get revoked. It makes no sense. But let's go read this. This is his appeal. It says the defendant, Jacob Norman, was charged with bill of information, felony, carnal knowledge of a juvenile. Following the bench trial, Norman was found guilty as charged and subsequently sentenced to 5 years hard labor. And it will go through the details of the crime. And here I just want to point out the first problem, and that's with the legislation. You might ask, well, what was the maximum time he was facing? The maximum time he was facing was only 10 years. So the judge decided that he needed a break. This guy, even though he put the state through the cost of a trial, and they had to put the victims on the stand, and they had to go through all of that, still thought, I'll only give you 5 years. But the legislation, Louisiana's legislation, only allowed 10, which makes no sense. And how does Louisiana view carnal knowledge of a juvenile? It's a person who is 17 years of age or older, has intercourse with consent with the person who's 13 years of age or older, but less than 17. So between the age of 13 and 17, that's carnal knowledge of a juvenile. And then what's the maximum sentence? Here it is. No one should be imprisoned for more than 10 years. So there's the problem to start with, okay? Because you would say, what? I mean, she's 13 years old. He was, let's go through it, 26. 13, 26. He was having, and we'll go through it in the details, full intercourse. They say at least 10 times intercourse. And the maximum that a judge could even sentence him is 10 years. What? I mean, by definition, it's full on SA. You can't consent. But Louisiana, there's some messed up stuff with this. And I hope that they can pass legislation to rip this garbage up and put in proper laws. You know, in Louisiana recently, they made the headlines because they said that now those who commit these crimes can face punishment of up to castration. That made the headlines. Wow, this is great. But it's all smoke and mirrors. It's all fluff. First of all, part of that law existed before. We've covered a parole hearing of a man who was chemically castrated. And that was from years ago. Maybe we should play it again because it got very few views. But what's important is that, well, I digress. And why is it just smoke and mirrors? It's because it's all about opting in. The inmate has to opt in, that he won't get paroled unless he's chemically castrated. Okay. But anyways, that has existed. We have seen it before. This is stuff that is very basic. This is something that a judge should not be restricted from handing out a higher sentence. And this shouldn't even be classified as carnal knowledge. This should be classified as something greater. And if you want to classify it as carnal knowledge, fine, but allow proper sentencing. So let me go through this. On April 17, 2012, the city police detective received information from the school resource officer at middle school concerning a 13-year-old student, CS. A family member reported CS was involved in a sexual relationship with a 26-year-old man, R. Prince Paul Jacob, who had been living with CS and her family. Thereafter, CS was interviewed at the Gingerbread House, a children's advocacy center in Shreveport, Louisiana. In her forensic interview, CS denied having a sexual relationship with Norman. However, CS's mother admitted to police that she was aware of her daughter's relationship. And by the way, mom was only charged with contributing to the delinquency of a minor, and it's my understanding that I think she just received probation. So, which you wouldn't be surprised. He gets 5 years. Why would you know? Moreover, CS's cousin, Bedonia, and Jessica informed police that they previously witnessed Norman having sex. On May 25th, 2012, Norman charged an alleged bill of information with carnal knowledge of juvenile in violation of. Norman chose to represent himself at trial following a 2-day bench trial, was found guilty. The classic narcissist, right? And what's the famous saying? If one who represents themselves has an idiot as an attorney, something like that. In accordance with the victim and her mother will be identified by their initials. It's funny, the mother's the predator too. She deserves none of that. Now he argued a new trial, saying evidence because now let's see his. I actually want to read you through this. I think many of you will find this interesting as well. And it goes through more details about how he was caught, etc., etc. So, new trial arguing that the trials court verdict was contrary to the law and evidence because, among other things, he was not permitted to cross-examine. I knew it. I knew that that's why he wanted to represent himself. He wanted to cross-examine the witnesses. Norman also alleged CS, who testified at trial that she had sex with Norman multiple times, had been coached into testifying against him. Norman's motion for a new trial was denied, and he was sentenced to 5 years at hard labor. He now appeals. So Norman also alleges that she was, he alleges that she was coached. So can you imagine, let's just think about this for 1 second. He is taken to trial, not a plea deal. He represents himself so that he has the ability to question the witness, a 13-year-old child. She was 17 at the time, though, of the questioning, but who cares? He's now questioning her. He's allowed to do that, to put her through that trauma, and the judge still says 5 years. Someone needs to investigate this judge, in my opinion. This is messed up. Norman, so in his appeal, Norman asserts that the evidence adduced at trial was insufficient to prove he had sexual intercourse with CS. I mean, I guess the judge could have found them innocent. So, it was a not a jury trial, but what are you saying? What are you telling the victim in this case, anyways, to sentence for to 5 years? In support of his claim, Norman notes that CS's trial testimony is contrary to the initial statement she made in her gingerbread house interview. Furthermore, Norman contends that none of the state witnesses testified that they actually saw him having intercourse. The standard appellate review for sufficiency of the evidence claim is whether, after viewing the evidence in light of the most favorable to the prosecution and rationality of fact that have been the essential elements of the crime are beyond reasonable doubt. Okay, blah, blah, blah. Okay, here again, they talk about what carnal knowledge of juvenile is, and that's what we knew. Okay, so a trial court detective testified he interviewed Gillette and her sister, who stated they saw Norman and CS having intercourse. Norman did not object to the detective's reference to either Gillette or Peter's statement. On cross-examination, Norman requested that the detective recorded interviews with Gillette and Peters played that recording in open court. In her interview, she stated she was at CS's house for a cookout when she and Peters went around the outside of the house to knock on CS's bedroom window as a prank. Then she said that before she knocked, she looked inside and saw Norman and CS having intercourse. She and Peters immediately went inside the house and confronted CS and Norman. According to her, Norman responded that he was a grown man and could do what he wanted. Gillette did not actually see CS and Norman having intercourse, but stated they were under the bed covers. CS did not appear to be wearing pants, and Norman's pants were pulled down. In an interview, Peter stated that she and Gillette walked around CS's house, knocked on the bedroom window while they were at CS's house for a cookout. So they're saying, a similar story. Peter's detective, blah, blah, blah. I can't pronounce the names. I'm sorry. Norman having sex with CS's bedroom window, but she did not. Peter said he and Goulet told DS that Goulet had seen, but DS told them to leave CS and Norman alone. Okay. Goulet and Peters then went inside the house, and Goulet told Norman that he needed to, quote, put his thing away. CS and Norman both responded by saying that they were grown and could do what they wanted. 2 days later, DS, CS, and Norman stayed with Peters at her home. Peter stated she saw Norman grab CS's crotch, butt, and breast. CS also told Peters that she had sex with Norman the evening before. Now, the detective testified that she interviewed DS. According to Detective McDonald, DS admitted that she allowed Norman to move into her house. This is mom. She allowed Norman to move into her house when he was having family problems. DS further acknowledged that she knew Norman and CS were having sex. That's mom, okay? And mom only got contributing to the delinquency of a minor. That's insane. DS stated CS would throw a fit and threatened to run away if she attempted to get Norman to leave the house. Now she's blaming her daughter, her 13-year-old daughter. On cross-examination, Norman requested that DS recorded interview be played in court. In the interview, DS stated Norman began coming over to DS's house and spending a lot of time with CS. DS explained that once she caught Norman in bed on top of CS, and upon seeing DS, Norman immediately jumped out of the bed with his pants around his ankles. At trial, DS testified that after CS admitted she was having sex with Norman, she took CS to a healthcare provider to get her birth control shots. DS asserted she never reported Norman's inappropriate behavior with CS. That mom, can you believe this pathetic DA allowed that she was, I think it was, they allowed her to maybe testify at trial and not, they did a deal with her. They did all of this. They made a deal with mom to say, you'll testify at trial and we'll, you will only give you this charge. And all of this, and still the judge gives 5 years. CS, 17 years old at trial, testified she dated Norman, calling it dated, for almost a year before his arrest. So she was 12 then when it started. CS, if that's the case, then they could have gotten him for first degree. They could have gotten him for a greater charge. CS stated that she and Norman had vaginal intercourse more than 10 times. CS further admitted that she lied to the forensic interviewer at the gingerbread house about not having sex with Norman in order to protect him. And couldn't they get him on each charge then and run the sentences consecutive? I just don't get it. Here's where it says mom got DS pled guilty to crime contributing to the delinquency of a minor. At trial, DS testified that she was not obligated pursuant to the plea agreement to testify. Here they're saying she wasn't obligated to testify or whatever. Peter looked into her window when she was having sex with Norman. At Norman's request, Gingerbread's house interviewer was played for the trial court. During the interview, CS denied multiple times that anything sexual occurred with Norman and claimed Norman never slept or laid in bed. When viewed in the light most favorable to the prosecution, the state presented sufficient evidence to prove that Norman committed felony crime of knowledge of a juvenile. At the time of the encounters, Norman was 26, CS was 13. CS testified that she and Norman had all sorts of intercourse. Alone is sufficient to prove the essential elements of the crime. I just can't. While CS initially denied having with Norman, testimony admitting sexual relations with Norman is corroborated by the testimony of her mother, as well as testimony of her cousins. It is not the duty of the court to assess CS's credibility or reweigh the evidence presented at trial. As a result, we find the record is sufficient to sustain Norman's conviction. Let's see what else they have here. Motion for continuance. After the first day of trial and following Detective Perdure's testimony, the admission of Gilles and Peter's statements, Norman noted his desire to subpoena, I guess, those two cousins or whatever, because of the state was not representing them as witnesses. And of course he did. He wanted to be in front of them. The state had no objection to Norman's request, and the trial court issued instanter subpoenas for both Gillette and Peters. The next morning, Detective Prouder testified the police were unable to locate either of them, and the trial court concluded that a good faith effort was made to secure the presence of the individuals at trial. Thereafter, Norman requested a continuance to attempt to personally locate the witnesses. However, the trial court denied Norman a motion for continuance. He's such a roach. What a roach. You would think that he would that he could, that's the problem when you represent yourself. He could have brought them up, asked to have them up ahead of time. I'm surprised the judge even gave him that. Okay, we'll look for them for one day, but I guess I'll put this link to this in the description. I think we've gone through it enough, but it's, again, you wouldn't believe it if you didn't see it. It's absolute madness. And then again, we do have that he was booked on August 1st, 2022 of first-degree sexual assault. And let me see if I can read that to you. A registered sex offender investigated for sexual assault on three different women, is behind bars on sexual assault and narcotics charges. Paul, Mr. Blah, 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 was first arrested Wednesday for possession of methed up. And after the deputies searched his home in connection with their investigation, released three recent separate sexual assault charges of the first degree and attempted first degree were added Friday. I don't know if he was actually convicted of that. It just doesn't make sense. How would that be possible in 2020 to be convicted of that and then to be out to get revoked again? But I do see he has sexual battery and sexual assault in first degree on his sex offender registry. None of it's making sense to me. That's all I can say. But I digress. I'm a broken record. It was a 9-minute parole hearing, and here I am ranting about it for 17 minutes. I hope that we're watching it. This is just the kind of stuff that needs to be heard and needs to be seen, because it makes no sense.
How many victims did you have, sir?
2, ma'am.
2, and their ages?
5 and 4.
And you heard correctly, 5 and 4, his stepchildren, and this cowardly DA, they sentenced him to just 20 years. But that's a gimmick, okay? Because he's up for parole only 5 years into his sentence, and whether or not the parole board denies his parole or not, he has a good time date in 1 year from now, 2026. Now make that make sense. How dare the DA and the judiciary put in charge of protecting us hand down a sentence who does this to his stepchildren, a 5-year-old and a 4-year-old, full-on assault, and that he can have a good time date 6 years into his sentence? This is the reality that we live in. Our heads have been in the sand until now. But now that this is broadcasted, now that the world can see what the judiciary has been doing, now we can at least protest. Now we can make noise about it, because there is no way that the majority, that even more than just the 0.1%, right? Those with the PhDs and those who are put in charge of protecting us, they think it's okay to do this, but we don't. The majority knows this is madness. Now we are about to watch the parole hearing of this monster who was indicted on full-on assault of a 4-year-old and his 6-year-old stepdaughters. He confessed, and this case was actually assigned to the Honorable Judge Bonnie Jackson. Sadly, it never made it to the Honorable Judge Bonnie Jackson, because we know that she would have sentenced him to multiple life sentences to the maximum. But the DA instead offered a plea deal. Make that make sense.
Good morning. The Louisiana Committee on Parole is going to be conducting hearings at headquarters in Baton Rouge. On my left is Mr. Chuck Tillis. To my right is Ms. Carolyn Stapleton. We are currently at by Dorsey Correctional Center, and we'll start at 9:12. With the staff there at Bayou Dorsey, introduce yourself.
I'm Randy Culpepper.
Thank you.
And I'm Jason Johnson. I'm the program manager for Steve Hoyle here and the Louisiana Sex Offender Treatment Unit.
Thank you. Sir, if you will, would you please state your name and your DOC number for the record?
Joe Rodriguez, DOC numbers 773316.
Try that again. 773116.
Yes, ma'am. Yes.
Okay.
Sorry.
We are waiting on some people who are here at headquarters. And while they come in, I'm going to do a little bit of paperwork. Sir, we find that you are a first-class offender, that you're currently serving a 20-year sentence for molestation of a juvenile and cruelty to a juvenile. You have a parole eligibility date of May 28th, 2024, a good time date of May 26th, 2026, and then a full term date of May 28th, 2039. Does that sound correct?
Yes, ma'am.
You have here in support today Marco Velasquez, your cousin, and Miss Valencia, your mother. We'll go ahead and Mr. Marco would like to make a statement, so we'll let him approach the podium and address your comments to the board. Tell us what you want to say.
Well, they told me to come because he needed some place to stay. I was gonna let him stay in my house.
Okay. So you're prepared for him to come and live with you?
Yes, sir.
And is your residence approved by sex offender laws?
Yeah, I guess, they sent papers to everybody's house and you know that you got a sex offender. And out of here.
Okay. All right.
He's gonna be working with me.
So he has employment with you.
Yes, sir. Okay.
All right, thank you very much. Mr. Rodriguez. How are you familiar with the victims in your case?
They were my stepdaughters.
And how long had you been in the role of a stepfather with these juveniles?
This was the second time that I dated their mother. We first started dating, it was September of 16 after the flood. And then we ended up breaking up for maybe 4 months, I think. And then we got back together.
Okay, so no, are you married to the mother of the children?
No, ma'am.
Okay, so you were serving in that. How old were you when you committed this crime?
30.
What country are you from? I notice you have a deportation detainer. What country are you from?
Mexico.
How long have you been in the country?
Since I was like 1.5.
So, sometimes I find when people are from other countries, they have different social norms. So you knew this was wrong.
Yes, ma'am.
You want to tell me why we should consider early parole for you?
Well, I just, during this time that I've been incarcerated, I've seen that, the things I've done really did hurt the girls. And just wanna, I think I'm ready to come home and, just be a better person. And also I wanna help my mother because she's sick. So she's got heart condition and she's got multiple myeloma, and I just wanna be there for her.
Your record indicates that you completed phases 1 and 2. Have you completed the 3 and 4?
We take our phase 3 test next week, and I think we should be done with phase 4 in January.
Tell me about your disciplinary conduct while incarcerated.
I think since I've been DOC, I've not had any write-ups or anything.
But you had some DOC.
I had, I think, one write-up when I was in River Bend, but they threw it out when I went to DB court.
Mr. Rodriguez, how many years have you served on your 20-year sentence?
I think it's 5.5.
Okay. We do have a risk assessment tool called the Static 99, and you had a moderate score. Do either of my colleagues have any questions?
How many victims did you have, sir?
2, ma'am.
2, and their ages?
5 and 4.
5 and 4. Okay, and I forgot. What did you say your age was? I forgot. I wouldn't have probably. What was your age?
30.
30. Okay, 30. Okay, and you were originally charged with aggravated, and then it was pled down. Am I correct with that? And molestation. Okay, it was pled down. And so from a life sentence, you got a 20-year sentence. That was
Yeah.
if you'd have gotten what you were originally charged with. That's all my questions.
Would either of the gentlemen, Mr. Culpepper, would you all have any comments you would like to make about this offender?
Sure. Again, my name is Mr. Johnson. I'm in charge of the sex offender program here. It is true that he is going to take his phase 3 test next week. I'd remind the board that our credit looks a little different in Cajun. So it's he's going to be taking all 4 phases in his time here. He's passed phases 1 and 2 with no problems. He's had no write-ups at this time. We also have him in substance abuse classes. We've determined that was an issue, and he takes his last test for that today. And he is currently set to graduate this program, assuming everything goes well, on, I think it's February 28th of next year.
I do a great job. Thank you.
Thank you.
Mr. Rodriguez, I believe the panel is prepared to vote. Sir, should I parole you today, it would nullify the severity of the crime and the impact on your victim. It would almost be as if it's just a slap on the wrist, and you got a 20-year sentence pled down. I believe that although you've done excellent rehabilitative programming, that the threat to society still exists, and my vote is to deny. Mr. Tillis?
Votes to deny also. More time need to be served.
And Ms. Stapleton?
And I agree that you need to serve your complete sentence, which was a lot less than what you could have gotten. And so my vote is to deny.
We thank the staff. Thank you, sir. The time is now 9:21, and we're going to complete our business at that facility.
Thank you.
Thank you.
So, got on the hall for a second.
I will.
And they denied, and we knew that a denial was coming. This new parole board, they just go through the motions, but I much prefer the old parole board, the process of doing it. And you know why? I think that it is important, even if you're going to deny anyways. I think it is critical that the world really understand just how warped these monsters are. You know, when you go through the parole hearing and it's like, oh, how old are they? How old are you? Okay, yeah, it's just the crime. You're denied. He's getting out anyways in a year in his good time. Can you even imagine some DA said, hey, what's so bad? 6 years he'll serve and he'll be out. I'm sure he'll learn everything he needs to in the Steve Hoyle program and he'll be good to go. And that DA, they should be sitting there with them because that's barbaric. But it's important for the parole board to dive in and have a longer session so that we can actually see how their minds work. Because given enough rope and enough, they will say, oh, she wanted it. Oh, it was her fault. She was hitting. They will say all those things, and the world needs to see how they say those things. In this case, this is what they gave this monster a plea deal for. It blows my mind that a DA would do this. This was written in 2019 when he's accused. 2025 he's up for parole. He will be free in 2026 at the age of 36. East Baton Rouge Parish Sheriff's Office has arrested a man following an SA investigation into a 4-year-old child, according to the arrest report. He assaulted the child, forcing her to use her words, put his wee-wee in her mouth. His wee-wee. Once in custody, Rodriguez refused questioning and asked for a lawyer. Instead, detectives ended further questioning and booked Rodriguez into Baton Rouge prison. I'm sorry, I must have made a mistake. I thought he had confessed. And what's interesting is that he was assigned to Judge Bonnie Jackson. And I think it was just around then, about a year later, 6 months later, about a year, 2 years later, Judge Jackson retired from the bench and then joined the parole board. But she would have given him life on the jury verdict. And I wish that he would have seen Judge Bonnie Jackson. And it's the idea that they would just give in and they would just surrender the DA to allowing this monster to get out in 6 years. It's disgusting. The 20-year sentence is a gimmick. And it needs to stop. These gimmicks need to stop. There's really only a few people that this gimmick is for. And it's for the public. It's for the public and it's for the victim. So they can tell the victim's mother, don't worry, your children, you won't have to worry about it for 20 years. You think they knew that within 5 years they'd get a notice at the door saying show up for a parole hearing? The bottom line is this monster will be out prowling the streets. Now, there's probably a good chance he gets deported, but that doesn't make the world a better place. Children, no matter where they're from, need to be protected. And this man needed to be locked up for life. And that's why, I don't know if it's possible. Maybe they could have a special division of ADAs that focus, a special crimes unit, but in the ADAs that only focus on sex crimes. The reason I say that is because then their winning percentage would be held at a different barometer. ADAs, they claim not to take these type of cases because they're difficult to win. They don't want to have a high loss percentage. But if you have an ADA that's only focused on these crimes, then they'll only be measured by that success. And that would be their job, to prosecute these crimes. There should be no excuse for not prosecuting these crimes and locking these people up for life. These are the most dangerous felons. What was it, his risk score? Moderate. And I bet you when he's done taking these programs, he'll go to a low. Pathetic. Sick. The whole thing is sick.
You transferred to another officer who told you could not live or stay at the alternate address because it's within 1,000 feet of a school. Okay, so then they said you could stay up to 3 days away from home. Well, they had not seen you within 4 days. The big problem is the landlord, Larry Davenport, says that he had been trying to locate you to collect rent.
We're going to watch a parole revocation hearing of a man who has been in and out of prison his entire life, over 7 felonies. His first crime against a child was in 1997, and since then, he has not been able to stay out of trouble. We'll watch as the parole board makes quick work of him.
The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. The time is now 12:29, and we're hearing offender at Caddo Correctional Center. And I see staff there. Would you please introduce yourself today?
Assistant Chief Dashay Darby. Deputy Davis classification.
Hey, thank you very much. We have before us an offender who is here for a revocation decision. On the panel today, did I introduce y'all?
No.
It's Mr. Tillis to my left, Ms. Stapleton to my right, and Ms. Ledoux. Do you have a parole revocation questionnaire in front of you?
Yes, ma'am.
Okay, that's a Supreme Court screening tool, and it shows that you are not eligible for appointed counsel today. So we're going to go ahead. What I'm going to do is read the allegations against you, and I'm going to ask you to enter a plea of guilty or not guilty or guilty with a statement. Okay, and then we'll allow you to make the statement at the proper time.
Okay.
So why don't you introduce your name with your DOC number?
Charles Ray Gibson Jr., 313261.
Okay. Mr. Gibson, you've been charged with violating condition number 3 of parole in that you moved from your listed residence without prior permission or knowledge from your parole officer, and you did not register a new address with the Caddo Parish Sheriff's Office. How do you plead?
I guilty with a statement.
Condition number 4, on 5/7/2024, you tested positive for THC, cocaine, and alcohol. And on 5/31 of this year, you admitted to using cocaine. How do you plead?
Guilty.
And number 9, you moved from your listed residence without prior permission or knowledge from your parole officer, in which conducting home visits were impossible. How do you plead?
Not guilty with a statement.
All right, so I'd like to ask you, you are you're currently on supervision for bank fraud, is that correct?
Yes, ma'am.
Okay. What is your statement about not being where you were supposed to be? Because there's a difference between where you live and where you put your head.
Exactly.
And you're a registered sex offender?
Yes, ma'am.
And so it's even more critical that we know where your head is.
Yes,
Okay.
ma'am. Yes, ma'am.
Give me your statement on that, please.
Well, see, I have a full-time employment job, and when my parole officer come by the house, I'm not there at that time, and also I report it every month, and I attend all my classes that I'm supposed to attend. But when she come by, our time difference is different. You know, I leave at 5 in the morning. I do landscaping service. When I leave at 5 in the morning until I get through with work, she says she's come around about 5:30. We miss each other. But when she calls me and tells me to come to the office, I come to the office.
Okay. Tell me the address that's on your parole certificate.
Northern Avenue. Shreveport, Louisiana.
So the problem is that your officer has to know, and I read in the report in the preliminary hearing, You transferred to another officer who told you you could not live or stay at the alternate address because it's within 1,000 feet of a school. Okay, so then they said you could stay up to 3 days away from home. Well, they had not seen you within 4 days. The big problem is the landlord, Larry Davenport, says that he had been trying to locate you to collect rent. Okay, so there's two people looking for you. The landlord looking for his rent money and your officer. If you had a phone, did she try to call you?
And she called me and I came in as she asked.
But she could pop in, in any time whenever you're at that address. You're supposed to be at that address. Did you work nights?
No, ma'am, I only work from 5 in the morning till whenever I get through with my work, 7:30, 8 o'clock at night. And plus I was attending my classes, which I supposed to been attending.
Hey, you understand that your roommate also said that he hadn't seen you.
Yes. They also work. And when our times are different. I mean, I comes in, they go out. I mean, I can't explain that, but
Okay. And you're not supposed to have drugs or alcohol.
correct.
Do my colleagues have any questions?
You've answered the ones I wanted to ask, so I don't have any.
Ms. Stapleton? Mr. Gibson, I only bring this up to show you that you're a 7th felony offender. You know the conditions. If a parole officer is having trouble getting in touch with you and you're doing drugs, you know what's going to happen.
Yes.
Okay. So my vote today is going to be to revoke your parole. Okay. Mr. Chillis,
I concur to revoke.
Ms. Stapleton.
And I concur to revoke.
Okay. So, sir, your parole has been revoked today. That concludes the hearing at Caddo. It's 12:30. Oh, no, wait, we have one more. I'm sorry. We have one more. Thank you, sir.
Okay.
But I'll tell you that this man has a long record. Like this, it's 7 felonies. So his first crime, let me give you a little bit of information that Sir Richard has. His first crime against a child dates all the way back to June 11, 1997. He was released 7/27/2006. So if you're going to spend 9 years in prison for battery against a child, and it's Louisiana, probably it was really bad and he pleaded down to battery. You got to assume it was one of the worst. And he gets out and he picks up many more felonies. One of the that he was charged with somewhat recently, as a matter of fact. Let me share this one with you. I'm looking at all of his arrests. So he has arrests 2/25/2016, 9/23/2016, 7/19/2017, 1/16/2019. But here's the one that it's just happened August 12, 2020. And that is failure to appear bench warrant, cyber stalking, violation of protection order 3 times. I don't know what that means, 3, 4, and 5. Stalking, cyber stalking again. I don't know why you get multiple counts or there are multiple victims. I don't know. Unlawful use of access to social media, failure to register as a sex offender, and those are the charges just in 2020. Like, what does this man have to do to get like a proper sentence? Really? I mean, I dare to think what that's all about. And let me see what the other ones are. Let me go. I'm going to read to you. I'm not going to share the screen because it shows information that YouTube doesn't like. But he has 2014 failure to register. Then he has 2016 attempt or commit, but it doesn't say for what. I don't know what that means. Then 2923 attempt or commit. Again, no idea what that is. $500 bail. 7/19/2017 battery of a police officer. Wow. Failure to register as a sex offender. Can you imagine? 2 counts of battery of police officer. And let's see what the next one is. I think is the one that we just read to you, where he has the cyber stalking and all that stuff. No, this is a different one. This is 2019. Failure to register as a sex offender. So, like, yeah, can't live within 1,000 feet of a school, but it's just, well, whatever. What can you do? I'm happy Mr. Tillis didn't say I do not revoke. I wonder how much time he's backing. Who knows? It's like as if they just don't care. But there you have it. And with that, we can move to the next hearing, or I'll let you go.
We do have a risk assessment tool called the Static 99, and you had a moderate score. Do either of my colleagues have any questions?
How many victims did you have, sir?
2, ma'am.
2, and their ages?
5 and 4.
5 and 4.
So, I mean, the child who was interviewed, you were giving gifts to a child. We have it in the folder. And so that looked bad.
I've never approached any children. I've never talked to any children at all, because they've even tried to involve my mother, who's a senior citizen, on this, saying that she was doing it also. I mean, I just got tired. I got sick of it.
Yeah, the officer was very complimentary of your mother, and so were all of the neighbors. And they were not trying to involve your mother in anything. Okay, so leave your mom out.